Today I'm going to be breaking down a monumental case. It spans a decade and carries the weight of about 150 years of history. And it's a legal battle from here in BC that could completely change how land transfers and land titles work, not just in the province, but for the entire country. I'm going to be dissecting the BC Supreme Court decision, Cowichan Tribes versus Canada. There are a lot of headlines and social media posts about it, but they don't all get into the details. This deep dive is about the claims brought by the Cowichan Nation, what they are seeking, what has happened so far, and what this could potentially mean for 95% of the land here in BC. So let's get right into it. This was not some quick legal fight. The trial started in September of 2019 and ended in November of 2023. That's 513 days in court. Of those 513 days, 447 of them were spent on just evidence alone. This should give you an idea of how hard it is to prove these historical facts. The judge even mentioned this themselves, saying this case was like trying to stitch a quilt together. Every piece of evidence, oral history, maps, written logs, it all has to fit together. Now, let's unpack that a little bit. The first thing the Cowichan needed to prove was their occupation before 1846. And how do you even prove facts that old? Well, they started with the oral historical record, which includes testimonies from multiple elders. And the courts really dug into how that information is preserved, because it's not just telling stories around a campfire. It is a very structured process. Knowledge is transferred in families and communities in big house ceremonies, and its accuracy is constantly tested and verified by the community. This historical record confirmed that this part of Lulu Island in Richmond was their sacred homeland and not just a temporary camp. It was a massive multi-neighborhood village with permanent structures and houses. Their occupation was seasonal, year after year, by the entire nation. And that consistency is what created the legal permanence. The written records from 1824 to 1859 were cross-referenced and confirmed this oral history. Accounts from the Hudson Bay Company stated that the Cowichan tribe was a dominant presence on the Fraser River. They were known as the leading nation in this quarter and the largest in the region. And then, to bring it all together, accounts from the 1820s were used to map it all out, and this showed that there were 108 houses belonging to the Cowichan within the land claim. So after all that evidence proving occupation, they then needed to prove exclusivity. They didn't just have to prove that they were there. They had to prove that they had exclusive occupation during that time and the capacity to control the land, which they did with their population alone. Records confirm that there were around 2,300 Cowichan members in that area at that time. The fact that they did not need to ask anyone permission to be there also helps prove their exclusivity. Now, I'm sure you're wondering, who would they even ask permission from? And the answer is other First Nation groups. The Musqueam also made a claim stating that those lands were in their traditional territory. The court weighed this heavily and found that while territories might overlap, the Musqueam did not occupy the village itself. The Tsawwassen First Nation also argued that the Cowichan were only there seasonally, which was also rejected as records show that the Tsawwassen were absent from that area during that time because they were hit hard by smallpox and moved upriver. This then proved the Cowichan's exclusivity. With both of those in place, the courts then ruled in favor of the Cowichan and granted Aboriginal title over section of land on Lulu Island, estimated between 600 and 800 acres. It also confirmed their right to fish in the south arm of the Fraser River. But one of the most legally explosive parts of this case revolves around the James Douglas Promise in 1853. James Douglas was a colonial administrator for the Hudson Bay Company, who became the Vancouver Island governor in 1851. He promised the Cowichan people that their land rights would be respected and that the crown would not take their lands without a treaty. The court found that this was a formal agreement and a constitutional commitment as it engaged the honor of the crown, a commitment that was not upheld. Right after the James Douglas Promise, the Cowichan were systematically blocked from accessing their lands on Lulu Island for the next 150 years. During this time, between 1871 and 1914, the province of BC issued fee simple crown grants on these exact sections of land. So, if the province sold the land to private owners, then how can Aboriginal title exist today? Well, That is the massive legal break here. The judge decided that those grants were given without legal authority on two different grounds. Firstly, they were made without statutory authority, meaning the lands were already designated as an Indian settlement, and under the law at that time, it made them ineligible for sale. So the province sold land that they didn't have the legal right to sell. And secondly, it was found that the grants were issued without constitutional authority, which means that the province does not have the power to extinguish Aboriginal title. Only the federal crown can do that. Because the province of BC acted illegally, the Aboriginal title cannot be extinguished, and so therefore it wasn't. But the court also stated that the private landowners have valid fee simple titles. So as of right now, this isn't a fight with the homeowners. And the Cowichan have stated that they don't plan to evict anyone. Another very important part of this case, and in my opinion a huge precedent setter, is the limitations defense. So in most cases in our legal system, if something happened 100 years ago, you can't go and sue today. The clock's run out. But through the doctrine of continuous trespass, the court was able to get around this. They were successfully able to argue that the ongoing existence of the fee simple grants on their land and the government's refusal to return the lands creates a new trespass every single day, therefore keeping the claim alive even after 150 years. The court's decision is that Aboriginal title exists and that the fee simple titles are valid as well, but it does not force anyone to leave their homes because it can't. The decision is supposed to be a starting point for the province, the crown, and the Cowichan Nation to figure out how to reconcile these competing titles. So what happens next? The court didn't order evictions, demolitions, or land seizures. It ordered something far more complex: negotiation. The negotiation of this unceded territory, depending on its outcome, will send shockwaves across the entire nation. Unceded means that the land was never given up or surrendered to the crown by way of treaty or other agreement. 95% of British Columbia is on unceded territory. From everything we know about Canadian law and how these cases have played out in the past, here are three paths that I think could most realistically happen. Number one, a co-governance or land sharing agreement. Cowichan holds Aboriginal title, homeowners keep their fee simple title, and the governments figure out how the two systems operate together through shared decision making, zoning authority, and revenue sharing. Number two, compensation. Since the province issued illegal crown grants, the remedy could be financial, through direct compensation or long-term revenue sharing, rather than returning the land. Although with the Cowichan waiting 150 years to get access to this land again, I don't know how likely the second one is going to be. And number three, a modern treaty. This would turn the Richmond lands into treaty settlement lands, similar to Tsawwassen First Nation, giving Cowichan full local jurisdiction. This is the most transformational scenario, but is also the most complicated and the slowest. Treaties take 10 to 20 years, thousands of pages, and multiple levels of ratification. So while possible, this is a long-term outcome, not an immediate one. The truth is, the ruling didn't close anything. It opened the door to a negotiation that has been closed for 150 years. And however these negotiations unfold, they're going to reshape not just Richmond, but the future of land, title, and ownership across BC and the entire country. If your property has been affected by this land claim, or you're wondering how future claims could potentially affect your property, book a one-on-one call with me using the Calendly link below, and we can go over it together.